Hi, this is Gina Wagers, and I'm going to be going over and reviewing some of the parental rights within the special education process. So first and foremost, just the history of parental rights. This idea predates the court itself, and it's just the basic belief that parents have the experience and the judgment to act in the best interest of their children, which includes decisions that impact or affect the direction of their education. So what are parental rights then? Essentially, these are procedural safeguards that are given to you, the parent in these situations, and they're designed to help you work better with the school to develop an effective educational program for your child. Within the state of Kansas, those include exceptional children, which can be either gifted children or children with disabilities. So who do these parental rights apply to? Well, in Kansas, a parent is defined as a biological parent, an adoptive parent, a person that's acting as a parent, whether that's a grandparent or step-parent or someone whom the child lives with. It can be a legal guardian, or in certain situations, it might be an appointed educational advocate or a foster parent. If it is an appointed educational advocate or a foster parent, there are some additional stipulations as far as those appointments and how they're made. And then there is some additional training that goes with that as far as making decisions when you're a foster parent. So what do parental rights involve or provide? Essentially, it's an opportunity for you to be involved in the process and give your input as a member of that decision-making team for your child during any and all meetings. And so how do you exercise your rights? Well, attending these meetings and providing input during the processes are important, and usually, typically, especially for a special education referral, that process can involve that initial request for an evaluation, the eligibility and determination meeting once the process of evaluation is done. Usually then there's a meeting to develop the individualized educational plan or IEP, and then yearly there may be a meeting for regular educational updates to the IEP. Anytime there needs to be a change made, there would be a meeting, and then anytime there's a reevaluation due for the student. As a parent, you do have a right to request the date, time, and location of that meeting, whether that takes place in person through a video conference or some other kind of conference call. You can also request an interpreter or a translator, depending on your language preferences, and you can also request to have other educational advocates present. That might include other people who are involved with the children or your child that have expertise and knowledge that's relevant to the IEP team, whether that's a therapist or a counselor or someone that provides service to the student outside of school as well. So how often should you be reviewing your rights? So as a parent, you should receive and review a copy of your parental rights in your special education notice. Usually this is once a year. Upon a referral, or if there's any instance of disciplinary removal from the school that constitutes a change in placement. And then there would be an additional manifestation hearing with that, but that would be a separate meeting or process. But you should be informed of these rights pretty regularly or have access to them. And again, just as a parent, it is your right to be provided with a physical copy or electronic copy of these rights. It should be in language that's easy for you to understand, and translation should be provided if that is necessary. So prior written notice is also something that you should be informed of as a parent. Basically, before certain proposed educational actions can be taken, you have to be given notice of them or informed of them. The school has 15 days to provide this information. Usually it needs to include a specific description of what action the school is taking or refusing to take. It should explain the evaluation procedures, assessments, records, or reports that the school plans to use, and any other description of any other options that the IEP team considered, and that you basically have access to that information in those reports. Just as a note as well, as your student continues to work their way through the education system, K through 12, once a student reaches 18 years of age, that's considered the age of majority. And at that time, those parental rights would transfer to that student. So the school district should be providing you notice, both to the young adult and the parent, at least 1 year before that transfer in that student's IEP. Just as a note as well, though, transitions from grade level to grade level or school to school, whether that's buildings within the district or to a new district, are important times for you to advocate for your students' needs and meet your IEP team as well. So that is highly recommended and is a right of yours as well. Parental consent to services. So before any services can be provided, changed, or discontinued, you have to provide your parental consent. which basically means that you've been fully informed of the activity that you're being asked to provide consent for, that you understand and you're agreeing in writing to the carrying out of that activity for your child and their plan, and that you have been informed of what records, if any, will be released in relation to those plans and to whom they'll be released to. Just a couple things to remember as you think about your consent. It is voluntary. You do not have to give your consent for certain services if that is not something that you would like. You may revoke or withdraw your consent at any time, but just note that revoking your consent is not retroactive, and it doesn't negate any actions that the school district had provided or that had occurred prior to your consent. So if there is a conflict or an issue with consent and trying to find a resolution and working with the district, you do have a couple of options for how you can resolve those issues. Mediation is typically between the parent, the district, and a third-party mediator. It does not require a formal complaint, but it's just a step in the process to trying to resolve an issue if you have a disagreement or disagree with some of the services or anything that might be taking place within your child's education plan. Due process hearing is another way to resolve issues within parental consent for services. Usually this does involve a written complaint against a school or district, and usually lawyers do become involved just to help advocate for each side. Requesting due process, just as a side note, is the only way that you can be maintained in your current placement as your child is receiving services. And then a more formal complaint, if any of these issues do not get resolved through mediation or a due process hearing. A formal complaint is a written complaint against the school or the district for violation of the state or federal laws, and it does typically end up having to be resolved in court. So just as some final thoughts here, additional comments, questions, or concerns. If you have any concerns regarding your rights or the special education process, you should contact your school's administrator. You can also get in touch with members of your child's IEP team, whether that be the school psychologist or their SPED case manager.